There are various approaches to this, and Canada can learn a great deal from international experiences like the UK. By discussing these various frameworks that properly support whistleblowers, uncovering wrongdoing ultimately benefits everyone, from preventing financial waste to corruption to safeguarding the public health and safety. But we know that despite their critical role in transparency and justice, whistleblower can often lack sufficient legal and governmental mental health support. So our conversation today is critical because, and this is more than a tagline. We really believe this, that protecting whistleblower means protecting truth, accountability, and ultimately democracy itself. So today I have the pleasure of introducing our speaker, Georgina Halford Hall, founding member and CEO of Whistleblower UK. In 2012, Georgina's life changed when, after raising concerns relating to allegations of abuse at a UK board school, she found herself under arrest and facing a lengthy jail sentence. Today, she leads the UK campaign for an office of the whistleblower, having led the team responsible for developing and drafting the bill going through Parliament. And she will be telling us about this, I hope, more. She is an HR professional and experienced troubleshooter, not only troublemaker, troubleshooter, working at a strategic board policy level and recognized as a global thought leader. Georgina leads Whistleblowing Awareness Week, running for the third consecutive year this year, from July 7th to the 11th, an event in Westminster that brings together politicians, regulators, practitioners, and senior thought leaders in the field of whistleblowing, compliance, governance, and safeguarding from all around the world. She regularly appears on TV, consults with governments, inform, advise. Her schedule only today is dizzying. And so we are really, really privileged to have her make the time and share her. And she's like, no, but yes, we are. So we really appreciate. Just quickly, the webinar guidelines. Our speaker will speak for about 30 minutes or so. And then during this time, I will be asking everyone to mute themselves to just minimize disruption. After the presentation, we will open the session for discussion. And just a note of advice for everyone, we will be stopping the recording. We want these conversations to be open, frank. And so I ask kindly that people don't record the question period. So we appreciate your collaboration because we understand that sometimes there are sensitive questions and sensitive answers. And in a landscape of political change, it's important to acknowledge that. If you have a question, I ask you to raise your little electronic hand and I will be calling on you. And if we experience what is called a Zoom bombing, someone comes and takes control, I will shut down the meeting and re-invite everyone to log back in so I can kick out the person. So just so we're ready to act. As Pamela mentioned, although these webinars are free, open to everyone, Whistleblowing Canada is an entirely volunteer-run organization that welcomes any financial support, of course, but also fundraising suggestions. Help us help others. And so we welcome any kind of support. I will now ask Georgina to lead us into this really essential conversation. And thank you so much for taking the time today to be with us.
Oh, that's gone. I've got to go. No. Good afternoon, everyone. Thank you so much for giving up your lunchtime to listen to me. And I really hope that, and I encourage lots of questions. I can't guarantee I might know the answers, but that brings me to this wonderful chap sitting next to me, Ali Kazmi, who is a barrister. He's unregistered at the moment and he's looking for a pupillage, but he's been working with Whistleblowers UK for nearly a year now, and he has just become indispensable, helping whistleblowers not just in the UK, but all over the world, and particularly engaging with people in Pakistan, his home country. So that's the sort of, he's not an interloper, so we're ready. And he will be answering questions as well, because this is all part of his training and upskilling to help him to deliver presentations like this to students, because we're inviting law students and other students across all disciplines who want to get involved as volunteers working with whistleblowers or studying this area. And Ali is going to take on the role of that sort of coordination, just to give you some idea. You'll be glad to know that the police aren't expected, but if you see them coming in, I'll pass to Ali today. Whistleblowers UK, as you know, it was set up in 2012 to provide help, support, and information to whistleblowers. And what we really quickly realised was that it's not just whistleblowers that need help, information, and support. It's actually everybody. You don't want to wait until you've whistleblown to know what information you need to know. So we've tried to provide an educational support for everybody as we've gone through. I've got an AI assistant helping me with something now. I'm going to turn that off. So that's a bit of the history to start with. But then we thought, well, we're getting nowhere with all these cases. We're just helping somebody, and then the next one comes along, and it's just like a conveyor belt. And somebody suggested, oh, let's have, you should have an APPG, an all-party parliamentary group for whistleblowing. And the wonderful Stephen Kerr, who's now a long-standing director of Whistleblowers UK, set up the first one for us. We've been the secretariat throughout. At the moment, we're sort of suspended because we're not sure where to go with it. And we don't have, as much as we'd like to say, the support from the UK government. We have lots of support from backbenchers across every party. That hasn't changed. But they get amnesia when they get into power, sadly. And I'm sure you've found that in Canada, where I've been following the wonderful work that Pamela and you, Paloma, have been leading for so long now. It feels thankless, but all of a sudden it sort of snowballs, it picks up. So don't ever get downhearted. Everyone said, oh, you'll never get an APPG. Oh, guess what? We got one. You're never going to draft a bill. Guess what? We haven't drafted one, we've drafted six. But we've improved each and every time, and it's due for another run out on Friday this week. I genuinely have to tell you, it's probably not going to happen because we're eighth on the list, and how private members' bills work, it's fundamentally if there's time in the calendar. So we're asking that it gets we're asking MPs to ask that it gets relisted. I don't doubt for one moment that this bill is going to come through at one point or another. But we've got amendments into the Employment Rights Act, and I'm going to talk all over the place because I'm so disorganised today. But I'll come on to all those bits as I take you through the presentation. So industry, people say, oh, they don't like whistleblowers. They actually do like whistleblowers. Our experience is that industry recognises that whistleblowing and whistleblowers are very valuable. The disconnect has been the piece of legislation that in 1998 came onto the statute in the UK, which was all embedded into employment law. And it's made it really difficult to avoid a complex litigation, a dispute. And it's made it really difficult to deal with the whistleblowing without dealing with the resulting dispute. It's set people up to fight each other, as we've all seen. So part of what we were looking at is, how do we ensure that the one thing that whistleblowers really want, which is for their concerns to be dealt with, can be dealt with? And we've taken soundings from all around the world, but the one thing that comes across over and over again is one central place. One central place, so everybody knows what it's called, everybody knows where to go, and then we become familiar. That we define whistleblowing in law, and I'm going to come on to that, but this central place should be for regulators, it should be for the members of the public, it should be for people in education and studying. It should be there for everybody, not just when you need it, when it's too late then, isn't it? It's like looking for the exit on an aircraft when it's already crashed. Need to know where you're going. So I'm going to put the presentation on and explain that this presentation, can you see it? I need to do share screen.
No, we can't.
Okay, share screen. Here it is. Right. Here we go. Now, I've deliberately left this title on here because it's really important to where we are at the moment in terms of the UK. There was a key promise made in the manifesto by Keir Starmer that Hillsborough Law, which is all about a duty of candour, would be a commitment. They made a commitment to whistleblowing, but not the office of the whistleblower. And they made a commitment to the misuse, or rather stopping the misuse of non-disclosure agreements, confidentiality clauses as they're called, in the UK. I'm hoping it's going to work. So we looked at, I think it's really important to understand that the Hillsborough Law came about because of the dreadful 97 deaths that happened in Hillsborough at the famous Liverpool game. What have I done with it? I've lost it.
Just need to minimize the, yep.
Apparently I haven't lost it at all. So it was all about duty of candour being a professional duty that professionals have to speak up. So police, fire, any civil servants, nurses and doctors. Sadly, at Hillsborough, there were some awful incidents of them trying to, in effect, wind the clock back to make the narrative work in order to avoid accountability by the police and other officials involved. So candour is a professional obligation to be honest. But I've said here, particularly when something goes wrong. Whistleblowing, as we know, is the act of reporting concerns about serious wrongdoing or potential harm, often before things have gone wrong, when you can foresee them or you can stop them from going wrong again. So what I've thought about here for this presentation is, so whistleblowing really is someone demonstrating a duty of candour, which is what the Hillsborough Bill is all about, and why Hillsborough Law now have supported us and calls for the Office of the Whistleblower. And you'll see this quote here. Imagine this police officer, a young police officer, on the football pitch, holding a young boy who was dying as he called for his mum. And to this day, she has never forgiven herself for doing what she was asked to do, which was remove reference to the time of death from the witness statement back to how it didn't fit the narrative. So all of these people died needlessly and avoidably, but senior police officers and other officials, all the way from the top down, covered up. So a legal duty of candour, and you'll see why this fits into our work, on public sector workers and the supply chain, demanding that they tell the truth, we're supporting. Because that's part of being a whistleblower, that's what they do. And this Hillsborough Law goes across all of the public. Legal representation for victims and witnesses, which is all about if they go into an inquiry, they get proper legal representation rather than having to stand there on their own when they don't have a law degree. It's about creating an ethical code of practice for every public body. And most importantly, for us in this talk, in the area we work, it's about protecting whistleblowers, people who speak up. So why do our existing laws fail? And we turn to the Public Interest Disclosure Act here. It's a really easy one. Most people actually don't know it exists. Our colleagues over at Protect did a survey, I think just over a year ago now, and they found that less than 30% of the public were actually aware of any law. But everyone knows the word whistleblowing, by the way. So workers are included in the law. Protected disclosures must be made to a prescribed person. Very few people actually know whether they're a prescribed person or not and what that duty means to them. When they get into litigation, and there is no choice but to get into litigation here, because the only thing that the Public Interest Disclosure Act sets out to do is for you to have a right to redress for any detriment that you have suffered, if you can prove that that detriment resulted from you blowing the whistle. And it turns into a David versus Goliath event. It's very expensive for everybody. And I'll give you some indication of this. I'm going to go off piece and Ali will keep nagging me, but I'll be good. So one of our whistleblowers spent £250,000 already. They happen to be in tech, but they're not even at a full hearing. They've been told that in order to get to a full hearing and through their 3-week hearing, they need to invest nearly £500,000 more for counsel, junior counsel and solicitor. This is ludicrous. It puts the price of justice beyond the reach of normal people, average people. Most people haven't got £50,000, let alone £500,000 and more. So this law has very much been prejudiced towards those who can afford it. Whistleblowers have got limited resources, and often they've got limited access to expertise, which is why we have a legal panel that provides pro bono assistance and information to whistleblowers to help guide them through what is an incredibly sort of a bear trap for the average person. So the law fails because people report something that they see going wrong and they expect somebody to do something. There is absolutely nothing within the law that allows that to happen. Pure and simple. So it fails at expectation one. And then whistleblowers spend the whole of the rest of their case, and often the rest of their lives, sadly, trying to go back to the beginning to resolve the issue that started their journey. And we see a lot of people who've been terribly damaged by that, which is why we have the brilliant Dr. Peter Harvey working with us as our consultant psychotherapist. And he provides a lot of pro bono assistance to people who are going through this journey and their families. And then turning here to this sort of duty of candor. At the moment, we see it in our NHS, it came in 2015. It's voluntary, it's unenforceable. There is no statutory body behind it. And of course, I don't want to talk about NDAs anymore, but we know with Harvey Weinstein and our lovely friends at Can't Buy My Silence, Zelda Perkins, exactly what's happened there and how things need to change. Because the Public Interest Disclosure Act turns a crime into an employment dispute. It turns a crime into a cover-up and into an employment dispute. And nobody looks at the crime or the employment dispute. And just out of interest, there's some statistics for you. 96% of all claims that go to an employment tribunal fail. And as you can see, all of these people do not speak up because they know that it's futile. The head of one of our non-statutory regulators said a year ago, let's make 2024 the year when we end fear and futility of speaking up in the NHS. Sadly, that hasn't changed. So what does the Office of the Whistleblower set out to do? And this is our bill. These are the principles of it. Number one, it's going to comprehensively define whistleblowing, whistleblower, and NDA. So nobody can slip through the nets on this. At the moment, it talks about a disclosure of information that in your reasonable belief tends to show that crime is, has, or might be happening, miscarriage of justice, a whole range of other things, or a cover-up of all of them, and it's in the public interest. We actually specify that within our bill so there can be no confusion, because this is how cases in the Employment Tribunal have historically lost. So it also specifies to whom the whistle may be blown. And we talk about relevant persons because prescribed person, most people say, well, I spoke to the relevant person here, my boss or the police officer, whoever it may be. And what this will do is protect those people who are complying with their duty of candor. It'll make it easier to access. Not everybody can get to their MP, and when they get to their MP, they don't know they don't all know that they are prescribed persons. And when they do get it, they still don't know what they're supposed to do with it because nothing's hard and fast. This law changes all of that. It uses statutory powers to protect whistleblowers from detriment. So from recriminations, it ensures that there will be proper investigations and there will be substantial fines and penalties to those who are found to have interfered with a whistleblower or to have interfered with an investigation or tried to suppress wrongdoing. And it's about the powers of restitution, compensating whistleblowers, not necessarily years down the line, not saying it'll be tomorrow, but certainly ensuring that people are left in a position where they can live. Because at the moment, too many whistleblowers tell us they have to choose, do I speak or do I live? That is not a fair and just society. When we're talking about creating a no-cost environment for everybody, because whistleblowers are the early alarm, they will capture patterns at the office of the whistleblower. Those patterns can be escalated to the government, to regulators, to ensure that people do their jobs properly. If you take our Post Office Horizon scandal or the contaminated blood scandal, loads of people knew. And in the COVID inquiry the other week, the chair of the COVID inquiry said, I need whistleblowers. Whistleblowers are people just like all of us. So this law is going to provide that early information to prevent crime and prevent harm, to protect the public interest, ban the use of NDAs. They're already banned. We're going to ban them again to make sure that they're still banned. It's just that the law hasn't been enforced is the point I'm trying to make. Setting, monitoring and evaluating effectiveness of regulators, regulations, and all of the help to provide continual regulatory improvement, because nobody ever does this. They do it and think it's done. It's like lacing your shoes. They don't stay laced. You need to keep looking at it and checking and improving. And education. If people don't know what their rights are, if they don't know what good looks like, how can they comply with it? How can they engage with it? And we're not suggesting any longer that we should take away the Public Interest Disclosure Act or employment tribunals. But what we're saying is when an employment tribunal identifies that a case around discrimination has a whistleblowing element, it has a statutory obligation to report it to the Office of the Whistleblower. So we try and keep on top of what's going on, again, about this early alarm and creating all of these, gosh, it's not working again, creating this safe environment. I'm moving myself around the screen so I don't lose my track or I really will gabble forever. So what are the objectives? Really quickly, normalise speaking up, provide proactive protection and support for whistleblowers. It's that reassurance. If I speak up, will I lose my job? The answer is going to be with this new office, no. Implementation and educate, a fair process for everybody. This isn't about beating up business. This is about giving business that sure footing that they understand how to engage with whistleblowing, not to see it as a fear factor, but see it as a benefit to business that's going to save them money. It's about accountability when things go wrong and recovering tax fraud and other fraud, doesn't matter where it is, because the taxpayer ultimately carries the can. Upholding the new duty of candour in the public interest. So people no longer have a choice to speak. They're going to be told you do have to speak if you work in the public sector or in that supply chain. This is about protecting them. Otherwise, we're just going to create more victims. Ensure that concerns are properly investigated without fear or favour, and they are escalated appropriately. We just don't want to have any more of this gagging or suppressing of whistleblowers. So these are our key areas for this piece of legislation, and it makes sense across every single sector. Ali, your magic touch. So the functions of the Office of the Whistleblower: set minimum standards, enforce and monitor compliance, prosecute offences under the Act, independent disclosure and reporting service. People feel safer as independent. If you don't trust your organisation, or if you sit outside of an organisation because you run an SME or because you are a witness like a parent, then you need somewhere to go. Public awareness, raising awareness all the time, having more of these presentations going around schools and hospitals and everywhere else, and providing support to organisations who are working with whistleblowers, and ultimately back to sharing information. The powers of the Office of the Whistleblower: they'll be able to issue information notices, no more hiding that information. And if you don't cough up the first time, action notices, you're going to do it now. If you don't, you're going to have a redress order and you're going to have to pay. This is where the fines and penalties come in. They'll have the power to put interim relief orders in place where whistleblowers are in some way removed from their job or they experience a detriment. They'll have the power to intervene to protect and compensate whistleblowers, whoever they may be. And they'll also have the power to publish results of the work that they do. They'll be able to monitor, evaluate, and improve the standards continually. These are new jobs for these offices. Normally, they require some sort of parliamentary intervention, but this has been built into our bill in order to make it more cost effective. So penalties, at the moment, the proposed penalties, and they are only proposed, up to 50,000 from individuals. I think that should have a few more knots. And up to 10% of annual global turnover, up to 18,000. 18, is that 18,000? 18 million. Yeah, 18 million, sorry. We were thinking tech companies, and they still think that's a drop in the bucket. But the main part of this is that it's built into the bill that the Secretary of State has the power to vary. Again, it's not usual to see this in pieces of legislation, and it's something that all of the members of Parliament and peers that we've talked to over the years have really liked about this. It's things that they wanted. Creating criminal offences, so making false statements. Currently, in the Employment Tribunal, that's not a crime. Destroying or withholding information. The case of Dr. Chris Day is absolutely earth-shattering. 90,000 documents were deleted only hours before the witness was meant to take the stand in order to look at his case. And the judge said, well, we'll never know if anything important was in them. That's just not acceptable. So intentionally or recklessly subjecting a whistleblower to the detriment. And if we go back to cases like the Jess Staley case, where the head of Barclays Bank, not once but twice, tried to hunt down the whistleblower, we'd say that's subjecting people to a detriment. So non-disclosure agreements, we can't get away from them. They are in the press every day, aren't they? So this is about ensuring that nobody is prevented from exercising their duty of candour, information is not suppressed, and that we're going to ban these completely. And we've worked with the team over at Can't Buy My Silence. I think we're still sort of hammering out some of the detail, but fundamentally we're on the same page. We want whistleblowers not to be subjected to this. There cannot be a choice of this or this, and both mean silence. Because whistleblowers speak up because they want change to happen. Whistleblowing is a public interest offence. Now, this is people who, particularly around the armed forces or MOD, official secrets, that if you speak up because of something that is happening that is fundamentally wrong, illegal, immoral, and unethical, that you can use this to avoid being silenced by the Official Secrets Act. I'm sure that when we get to committee stage, there'll be quite a lot of debate in this area, but we'll cross that bridge when we come to it. So no civil claims can arise after making protected disclosure or exercising your duty of candour, including breaking of old non-disclosure agreements. So you can't be sued. Whistleblowers are going to be protected against self-incrimination because lots of whistleblowers are actually part of the problem until they realise they are part of the problem, and then they speak up. It's a fact of life. You don't always know you're doing the wrong thing. Something might trigger that. So we want to protect those people. So we did a word cloud at the beginning of this year. We asked people as part of a survey that we're running, and the results will come out during Whistleblowing Awareness Week this year. And these are the words that we use to describe the Public Interest Disclosure Act. And this was including lots of people from business who are supporting us and working with us. Unclear, dangerous, traumatic, catastrophic, risky, bad. Confusing. Somebody even said unknown, look, shoddy. I think that's a bit mean. But I think about injustice just about sums up this particular piece of legislation, because whistleblowing has been at the forefront of sort of the British psyche since the early 13th century with the K-Tam laws that have been adopted in the US. We were the first European country to bring in a whistleblowing legislation, which was really, I think it was ambitious. It just hasn't met those expectations. because people didn't know what they didn't know, but we've taken far too long to start to correct these problems. And so the purpose of this particular piece of legislation is to transform the way we think about whistleblowing, the way that we think about whistleblowers, and to make the whole experience so much more positive and not combative and hostile. So this was our call to action. Hillsborough law, it's actually been pushed back. It's still being battered around. We still don't have a draft law. Office of the Whistleblower, again, that's like to be pushed back, sadly. But what isn't pushed back is Whistleblowing Awareness Week. And this is where you, as our friends and part of our whistleblowing family, we'd like you to join in. On the morning of the 7th of July, or the afternoon, depending on where you are in the world, we can do a whole session or a couple of sessions where you guys can all get involved and share what you're doing, what your experiences are, and why you either support us or don't, or how we can make it better. Because this is all part of all of us together trying to work as a global team to resolve a global problem. And it is a global problem. It's about overcoming barriers of language, of culture. This isn't easy, as we've seen with the EU directive. I think the EU directive is pretty much, a disaster. And I'm sure that some people won't agree with me, but that's fine. And you can ask me why I think it is. But I'm going to wrap up because I'm nearly at past. I don't want to overstay my welcome here. Apart from to flag rewards, which is a very big thing in the UK, because we've now announced some rewards programs and we're starting to push them. But I would say to that, and I support rewards, I support incentivization, but more than that, we have to prioritize protection. Because most of the whistleblowers I know, doesn't matter what they're blowing the whistle about, all of them want protection more than they want incentives. The incentives are useful later to keep their life going if it gets damaged, but fundamentally, protection, protection, protection every time. Do I need to press something else? So here's my thank you. Here's some of our main partners, and you can see we've got the CMA in there, we've got Serious Fraud Office, we've got lots of people now working with us, and we're super happy to add your logo, which is in there somewhere. I know Whistleblowers of America is there. I know that you're there somewhere. But thank you so much, everybody. Any questions?
Thank you so much, Georgina. Fascinating. And, I really like and appreciate the acknowledgement of this human nature of you don't know until you know. And, we need to allow this learning to happen. And it's part of this accountability journey. Oh, I'm doing the wrong thing. I should speak up, but I don't want to be retaliated against because, now I know better. So I really appreciate also kind of thinking through that. It's not something that people actually acknowledge often. So now we are open for discussion. I will kindly ask Pam to stop the recording because we like to have these really open conversations.